Welcome to the Kemp IT Law vlog. I'm Deirdre Moynihan. In this, the latest in our series of GDPR-related vlogs, we're going to look at the new rules applicable to contracts between controllers and processors under the GDPR. A data controller determines the purposes and means for processing personal data. A processor, on the other hand, merely processes personal data on behalf of the controller. Two of the key differences between the regime applicable under the GDPR and existing data protection law in the UK are the facts that the GDPR will apply directly to processors and that the GDPR requires a written agreement between controllers and processors that includes the following 8 points. 1. Details of the subject matter and duration of the processing, the nature and purpose of the processing, the type of personal data and categories of data subjects, and details of the obligations and rights of the controller. 2. A requirement that the processor processes personal data only on the documented instructions of the controller. 3. A requirement that the processor ensures that persons authorised to process the personal data are bound by obligations of confidentiality. 4. A requirement that the processor takes all measures required pursuant to Article 32 on security measures. 5. A right for the controller to consent to the appointment of any sub-processors. 6. Terms requiring the processor to assist the controller in responding to subject access requests, breach notifications, and to enable both parties to comply with the GDPR's obligations with respect to technical and organisational measures, security, impact assessments, and consultation with authorities. 7. An obligation to return or delete personal data after completion of the services and to delete copies unless required by EU or member state law. And finally, 8. An obligation to make available to the controller all information necessary to demonstrate compliance and to allow for audits and inspections by the controller or a third party designated by the controller. To assist with compliance, the GDPR allows for the creation of standard contractual clauses and for adherence to approved codes of conduct or certification schemes. As yet, neither of these options has been approved. The net effect of all these requirements is that controllers and processors alike will now need to put in place more detailed clauses regulating their relationship. This will require controllers to do more due diligence to ensure processors provide sufficient guarantees to meet the requirements of the GDPR and to more closely monitor their processors' performance. For processors, the new requirements increase business and legal risk. Failure to comply can amount to a breach of contract and also a breach of the GDPR that could result in fines, sanctions, and an obligation to pay compensation to data subjects. It's therefore important for processors to consider the issues now and put in place procedures to ensure it can comply with these obligations. If you'd like to know more about the GDPR's requirements and its implementation in the UK, please see our vlogs, blogs and white papers at www.kempitlaw.com.